U.S. Supreme Court overrules Chevron Reshaping, the future of regulatory litigation. The U.S. Supreme Court issued its long-anticipated decision in Loper Bright and Department of Commerce, a pair of consolidated cases asking the court to reverse its seminal decision in Chevron. And as expected, following oral argument, the court accepted the invitation and overruled Chevron in a 6-3 decision. And under the newly minted Loper Bright doctrine and the majority route, courts must exercise their independent judgment in deciding whether an agency has acted within its statutory authority, as the APA Administrative Procedure Act requires. And for more than 40 years, judicial review of agency interpretation and of statutes has been guided by Chevron familiar two-step framework. At the first step, by the way, courts were instructed to ask whether Congress has directly spoken to the precise question as at issue, and if the answer to that question was no, then at the second step, courts were required to uphold the agency decision unless the decision was not a reasonable construction of the status. And as a result, by the way, because broad statutes are often susceptible to multiple reasonable interpretation, and the statutes frequently changed meaning from administration to administration, and creative agencies were rarely stumped in their search for a broad statutory grant that would support specific policy or political objectives. And over time, Chevron had been cited in over 18,000 federal court decisions and had been invoked to uphold at least hundreds of agency actions, and no doubt behind the scenes. And Chevron has influenced agencies' approaches to countless other decisions. And in Loper Bright, the Supreme Court held that Chevron difference in incompatible with the APA and with courts' paramount duty to interpret the laws that Congress enacts. And in reaching this conclusion, the majority relied on the language of the APA, and which assigns to federal courts the authority to decide all relevant questions of law and interpret constitutional and statutory provisions and determine the meaning or applicability of the themes of an agency action, and as well as pre-New Deal decisions, and stressing that agency determinations and entitled to respect but not blunt allegiance. And the court also held that stare decisis didn't require continued adherence to Chevron, and the court held that Chevron wasn't merely wrong but fundamentally misguided, and that it has proven unworkable. And as 4 decades into the Chevron experiment, the court still hadn't arrived at a clear definition of ambiguity, and or as Justice Scalia but it's in a law review article, and how clear it in clear, and further in a point of stark disagreement with dissent. And the court held that Chevron hadn't engendered substantial reliance because almost since its inception, and the court has had to continually reshape Chevron through a series of patchworks and exceptions, and the Chevron Step 0, and the major questions, doctrine, and so on, and rather than continue to chip away at Chevron's excesses, Loper Bright throws the doctrine out in the toto. And while Loper Bright signals the end of an era, whether its impact will be gradual or revolutionary remains to be seen, and mindful of the potential flood of lawsuits challenging all decisions that relied on Chevron, and the majority stressed that holding in cases that specific agency actions are lawful and are still subject to statutory despite our change in interpretative methodology, and that are Reliance or Chevron, by the way, is not a reason for overruling a president. And at the same time, however, the court noted that a prior decision's reliance on Chevron may suggest that the president was wrongly decided, and insofar as such a decision failed to grapple with legal arguments in deference to the agency, and the two court undermine the force of stare. In addition to judicial precedents, also in question will be agency rulemaking and other final actions that relied expressly or implicitly on the availability of Chevron deference.